The Succession to the Crown Act 2013 is an act of the Parliament of the United Kingdom. It altered the laws of succession to the British throne in accordance with the 2011 Perth Agreement. The Act replaced male preference primogeniture with absolute primogeniture for those born in the line of succession after October 28, 2011, which meant the eldest child regardless of gender would precede their siblings. The Act also ended the disqualification of a person who married a Roman Catholic from the line of succession, and removed the requirement of those outside the first 6 persons in line to the throne to seek the sovereign's approval to marry. It was brought into force on March 26, 2015, at the same time as the other Commonwealth realms implemented the Perth Agreement in their own laws. Background. Under the Act of Settlement 1701, the throne of the Kingdom of England was settled on the Electress Sophia of Hanover and the heirs of her body, this phrase being understood under English common law to imply male preference primogeniture, meaning that brothers would precede sisters in the line of succession. It also prevented a papist from inheriting the English throne and removed those who had married Roman Catholics from the line of succession. The treaties that created the Kingdom of Great Britain in 1707 and the United Kingdom of Great Britain and Ireland in 1801 specifically applied these provisions to the new British throne. Article 2 of the Acts of Union 1707 stated that the succession of the monarchy is settled by the Act of Settlement 1701, and the ban of papists from inheriting the throne was to continue according to that Act. Article 2 of Acts of Union 1801, again maintained that the succession rules in place in the new United Kingdom of Great Britain and Ireland should be continued limited and settled in the same manner. From the time of Queen Anne, male preference primogeniture has operated only twice to displace a living female descendant by a younger brother, when Princess Augusta of Great Britain's younger brother became George III on the death of their grandfather George II. And when Victoria, Princess Royal's younger brother became Edward VII on the death of their mother Queen Victoria. The present Princess Royal is the younger sister of the heir apparent. Her place in the line of succession is not affected by the provisions of the Act relating to male preference, in that she remains head of the line following next after those headed by her younger brothers, whose lines continue to precede hers under male preference. Agreement in principle and final consent equals. In December 2011 the statement of Friday 28 October 2011 issued at Perth was published in the House of Commons Committee report. It stated that the Prime Ministers of the 16 Commonwealth nations of whom Her Majesty the Queen as head of state had agreed in principle to work together towards a common approach to amending the rules on the succession to their respective crowns, and that they would wish unanimously to advise the Queen of their views and seek her agreement. The statement continued. All countries wish to see change in 2 areas. First, they wish to end the system of male preference primogeniture under which a younger son can displace an elder daughter in the line of succession. Second, they wish to remove the legal provision that anyone who marries a Roman Catholic shall be ineligible to succeed to the crown. There are no other restrictions in the rules about the religion of the spouse of a person in the line of succession, and the Prime Ministers felt that this unique barrier could no longer be justified. The Prime Ministers have agreed that they will each work within their respective administrations to bring forward the necessary measures to enable all the realms to give effect to these changes simultaneously. In a letter to the other realms' heads of government, prior to the Perth Agreement, British Prime Minister David Cameron had additionally proposed to limit the requirement to obtain the monarch's permission to marry to the first 6 people in line to the throne. On December 4, 2012, Deputy Prime Minister Nick Clegg announced, "He government has received final consent from all the Commonwealth realms to press ahead with a landmark bill to end the centuries-old discrimination against women in line to the British throne at the soonest possible opportunity." This confirmation means that the government will seek to introduce the succession to the Crown Bill in the House of Commons at the earliest opportunity allowed by the parliamentary timetable. Progress in Parliament. The bill was published on December 13, 2012, and after passing both Houses of Parliament it received royal assent on April 25, 2013, immediately before the prorogation of Parliament that day. But this time an assenting bill of the Canadian Parliament had already received royal assent on March 27, 2013 as the Succession to the Throne Act, 2013. The purpose of the Succession to the Crown Act is to give effect in the United Kingdom to the Perth Agreement. The British government announced that the Act's provisions were not intended to come into force before the appropriate domestic arrangements were in place in the other Commonwealth realms. Provisions Gender equals, males born after October 28, 2011 no longer precede their elder sisters in the line of succession. The first people in the line of succession to be affected by the changes on the date they came into force were the children of Lady Davina Lewis, her son Tani and her daughter Senna, who were reversed in the order of succession, becoming 29th and 28th in line respectively. Marriage to Roman Catholics equals, marrying a Roman Catholic no longer disqualifies a person from succeeding to the crown. The explanation published when the bill had been introduced mentioned that those who had lost their places in the line of succession by marrying a Roman Catholic would regain their places, but that those with a realistic prospect of succeeding to the throne would not be affected. The first person in the new line of succession to be affected by this change when it came into effect was George Windsor, Earl of St Andrews, who had married a Catholic in 1988, and was restored to the line of succession in 34th place, after the Duke of Kent. The provision of the Act of Settlement requiring the monarch to be a Protestant continues. Sovereign's consent to royal marriages equals, the Royal Marriages Act 1772 is repealed. Instead, only the first 6 persons in line to the throne require the sovereign's approval to marry. Marriage without the sovereign's consent would disqualify the person and the person's descendants from the marriage from succeeding to the crown. However, the marriage would still be legally valid. When the Act came into force, the Duchess of Cambridge was expecting Princess Charlotte, upon whom the Act has no practical effect. From her birth on May 2, 2015 she was 4th in line to the throne, after Prince George of Cambridge and ahead of Prince Henry of Wales, just as she would have been had the Act not been passed. However, due the provisions of the Act, she will retain her place in the succession ahead of any younger brothers who may be born. Gallery, first 6 in line from May 2, 2015 equals. Marriages legally void under the Royal Marriages Act 1772 will be treated as never having been void, except for purposes relating to the succession to the crown, provided all the following conditions are met. Neither party to the marriage was one of the 6 persons next in the line of succession to the crown at the time of the marriage. No consent was sought under Section 1 of that Act, or notice given under Section 2 of that Act, in respect of the marriage. In all the circumstances it was reasonable for the person concerned not to have been aware at the time of the marriage that the Act applied to it. No person acted before the coming into force of the 2013 Act on the basis that the marriage was void. Consequential amendments provisions in the Acts of Union 1707, between England and Scotland, and in the Acts of Union 1800, between Great Britain and Ireland, that involve the Crown as subject to provisions of the Act. Several sections in the Bill of Rights 1689 and the Act of Settlement 1701 involving marriages with papists were repealed. Any references to provisions relating to the succession to, or possession of, the Crown also include, by reference, the provisions of this Act. However, the sections that ban Catholic succession were not repealed. Catholics are still officially termed as being naturally dead and deemed to be dead in terms of succession. This discrimination was first legislated in the Bill of Rights 1689. Jacob Rees-Mogg also confirmed a Euro-OEV Act of Settlement deems somebody who has been a Catholic for a minute to be dead in terms of the succession, and it passes over them as if they were dead. It is an absolute. If at any moment in their whole life they were in communion with Rome, they are excluded from the throne, deemed to be dead. Euro. Mark Durkan compared this with McCarthyism, a Euro-Owean effect. It is the McCarthyite question, are you now or have you ever been a Catholic? For anybody who has ever been a Catholic in any shape or form, that is it, they're out. They count as dead for these purposes. Euro. As the monarch's eldest son will no longer automatically be heir apparent, the Treason Act 1351 was also amended, so that encompassing the death of the monarch's eldest son and heir is now extended to murdering the heir, whatever their gender. Another amendment to the Treason Act is that, whereas it had been treason to violate the monarch's eldest son's wife, It is now only treason if the eldest son is also the heir to the throne. The Regency Act 1937 was amended to require the regent to be a person who had not been disqualified from the succession by marrying without the monarch's permission under the 2013 Act. Commencement none of the provisions of the Act altering the law, including those which will or may affect any direct or collateral line of succession to the British throne, were to come into force until a day appointed for it by a commencement order made by the Lord President of the Council. When publishing the bill, the government had announced that it was expecting to bring the provisions into force at the same time as the other realms would be bringing into force any changes to their legislation or other changes necessary for them to implement the Perth Agreement. This was done on March 26, 2015. Territorial extent the Act extends to the whole United Kingdom. It has no provision on extent, but by necessary implication it extends to the Crown dependencies and British Overseas Territories, following the precedent of other acts affecting the sovereign such as the Accession Declaration Act 1910 and the Regency Acts of 1937, 1943 and 1953. However, Jersey passed its own succession to the Crown Law 2013 to give effect to the provisions in Jersey law. External reference: the legislation passed in the realms of Australia, Barbados, and Canada make reference to the United Kingdom legislation in different ways. The Succession to the Crown Act 2015, passed by the Parliament of the Commonwealth of Australia, is expressed to be for changing the law relating to the effect of gender and marriage on royal succession, consistently with changes made to that law in the United Kingdom, so that the Sovereign of Australia is the same person as the Sovereign of the United Kingdom. The Succession to the Throne Act, 2013, passed by the Parliament of Canada, refers to the bill, the alteration in the law touching the succession to the throne set out in the bill laid before the Parliament of the United Kingdom and entitled A Bill to make succession to the Crown not depend on gender. To make provision about royal marriages and for connected purposes is assented to. The Parliament of Barbados Succession to the Throne Act, 2013, uses similar wording to Canada's law. The Parliament of Barbados acquiesces to the alteration in the law relating to the succession to the throne set out in the bill laid before the Parliament of the United Kingdom and entitled A Bill to make succession to the Crown not depend on gender. To make provision about royal marriages and for connected purposes. Commentary. Royal family On January 6, 2013, the Daily Mail reported that the Prince of Wales had serious concerns about the proposed legislation. In a meeting with Richard Heaton, Permanent Secretary at the Cabinet Office, the Prince is said to have raised concerns about what will happen if his grandchild is allowed to marry a Roman Catholic, and the potential impact of changing the rules of royal succession for other titles that are currently passed down the male line. A spokesman for the Cabinet Office and a spokesman for the Prince declined to comment on the Daily Mail report. On January 9, 2013, Prime Minister David Cameron said in regards to the proposals that there has been very thorough contact between No. 10 Downing Street and the Palace, and all the issues are settled and agreed. Church of England On January 21, 2013, the Church of England published a briefing endorsing the bill's provisions and stating, the use of fast-tracking procedures, for the bill is acceptable. The same day, The Telegraph reported that the Church of England had written to MPs to express its official backing for the proposed changes. House of Commons A report on the rules of royal succession was prepared by the Political and Constitutional Reforms Select Committee of the House of Commons, chaired by Graham Allen, and was published in December 2011. The report welcomed the proposals, but drew attention to connected issues that may be raised when the proposals are debated, depending on the scope of the bill, especially the future role of the Crown in the Church of England, and the continued ineligibility of women to succeed to the majority of hereditary peerages, which remains a matter of public interest for as long as it has an impact on gender balance in the House of Lords. On September 9, 2012, the British government published a response to the report, reiterating that it intended to implement the Perth Agreement but had no plans to change the laws of succession to peerages or the established status of the Church of England. House of Lords On January 21, 2013, the House of Lords Constitution Committee published a report opposing the government's plan to fast-track the bill, citing the legislation's constitutional significance and possible unintended consequences. In response, the government expanded the time allocated for the bill's debate in the House of Commons from 1 day to 2 days, and it decided not to fast-track the bill in the House of Lords, where the normal time limits were observed. Bill stages. The first reading of the bill in the House of Commons took place on December 13, 2012. Passage of an allocation of time motion, the second reading, and the committee stage took place on January 22, 2013. The report stage and third reading took place on January 28, 2013. The only amendment made in the House of Commons was to insert the words "from the marriage" after the word "descendants" in Section 3(3), which was passed without debate. The first reading of the bill in the House of Lords took place on January 29, 2013. The bill passed second reading on February 14, 2013 and was reviewed by committee on February 28, 2013. The report stage was on March 13, 2013. The bill was passed at the third reading on April 22. No amendments were made to the bill in the House of Lords, and it received the royal assent on April 25, 2013. Notes. See also, Monarchy of the United Kingdom, Royal Succession Act 2013, New Zealand legislation to implement the Perth Agreement. Equality Bill, related UK legislation pertaining to the succession of female heirs to hereditary titles and peerages, Perth Agreement 2011 and other articles, linked directly or indirectly a Wikipedia book. References. External links, full text of the Act, full text of the bill as introduced to the House of Commons, explanatory notes of the bill as introduced to the House of Commons, research paper by the House of Commons Library.